This episode was produced by Bach Pro Se. Run your own legal research at prose.trybach.com.
Imagine the legal system actually moving at the speed of an emergency.
Right. Which is not how we usually think of it.
Exactly. I mean, we're totally conditioned to think of the law as this slow, agonizing glacier of paperwork and, procedural delays. Like, you file a form, you wait months, maybe years, just to stand in front of a judge.
Yeah. Usually it's incredibly slow.
But there's a specific legal alarm you can pull in Florida where, in a matter of hours, a judge can legally order someone out of your home, remove their firearms, and give you full custody of your kids. And I mean, all before the sun goes down.
It completely flips the script on how courts usually operate.
Yeah.
Like the law generally prioritizes deliberation over speed. It wants to weigh every single angle. Mm-hmm. But when the system recognizes that someone is in imminent physical danger, the rules of engagement just shift entirely. The priority becomes immediate, physical safety.
Right. And while you might usually join us for these deep dives just to, feed your curiosity and learn how things work behind the scenes, today's deep dive into Florida's legal system could be a literal lifeline for someone you know. Or even for yourself.
Absolutely.
We're going to completely demystify the legal tool known as an injunction for protection against domestic violence. And we're looking specifically at how this unfolds in Broward County, Florida, because honestly, when you're in the middle of a terrifying situation, the absolute last thing you need is to be paralyzed by legal jargon, right? Or some confusing courthouse maze.
Yeah, understanding the actual mechanics of this protection changes everything. I mean, it takes an incredibly overwhelming situation and breaks it down into actionable steps.
So let's start right at the gateway. Before a judge can grant any kind of protection, you really have to know who legally qualifies to ask for it.
Right.
I sort of like to think of filing for an injunction not as preparing for a full-blown trial, but more like pulling a fire alarm. You don't need to put out the fire right then and there.
You just need to show there's smoke.
Exactly. You just need to show the authorities there's smoke. So under Florida law, who is actually allowed to pull this specific alarm?
Well, the foundation for all of this is found in Florida Statute, Section 741.30. That's the part of the law that actually creates the domestic violence injunction. To pull this alarm, you have to meet two requirements. There's a relationship test and a danger test.
Okay, a relationship and a danger test.
Right. The danger part means you must either be a victim of domestic violence already or, and this is crucial, have reasonable cause to believe you're in imminent danger of becoming a victim. So the law explicitly does not require you to wait until you are physically attacked to seek court protection.
Wow. Okay. That's a huge distinction. But the relationship test is where I imagine things get complicated because families and living situations are rarely simple.
Yeah, they really aren't. And the law handles that under Section 741.28, which defines a family or household member. It covers all the obvious categories like spouses, former spouses, people related by blood or marriage. It also includes people who are currently living together as if they're a family or who have lived together in the past.
But that leaves a pretty big gap, doesn't it?
Yeah.
Like, what if two people have a child together, but they never actually lived under the same roof? Or, maybe they barely even dated. They wouldn't fit that definition.
You'd think so, but the statute actually carves out a specific exception for that exact scenario. If two people are parents of a child in common, they automatically qualify for a domestic violence injunction.
Wait, really? Just automatically?
Automatically.
Okay.
It completely bypasses the living requirement. It does not matter if they were never married, and it doesn't matter if they never spent a single night in the same dwelling. Sharing a child links them under this specific law.
Oh, wow. I mean, that makes perfect sense, considering how much interaction is required to co-parent. So, let's look at the reality on the ground. Someone meets that criteria, they're in danger, and they need help today. If they're in Broward County, what does the actual day of process look like?
So in Broward County, the central hub for this is the Domestic Violence Division. That's at the Central Courthouse in downtown Fort Lauderdale, or you can go out to the West Regional Courthouse in Plantation. And one of the biggest barriers preventing people from getting legal help is money.
Oh, definitely. Lawyers are expensive.
Exactly. So the system completely eliminates it. There are absolutely no filing fees for this. Furthermore, you do not need to hire a lawyer to walk through those doors.
Really? Because it's hard to imagine navigating a courthouse without an attorney whispering in your ear. I mean, the paperwork alone usually requires a law degree to decipher.
Yeah, normally that's true.
Yeah.
But here, the statute legally mandates that the clerk of court must step in and assist you.
The clerk actually helps you.
Yes. They provide simplified forms that are designed for regular people to understand, and they are required to help you figure out how to complete them. The clerk also has a legal duty to ensure your privacy to the extent practical while you're filling out the petition. So you walk in with your photo ID, any evidence you might happen to have on you, and you spend an hour or two detailing the danger you're facing.
Okay, so you fill out the paperwork, you sign it under oath, and then what? Because it seems like this is the point where the bureaucracy usually kicks in and tells you to go home and, wait for a letter in the mail with a court date.
And that's where the speed of the system takes over.
Yeah.
The exact same day you file that paperwork, it goes straight to a judge's desk. The judge reviews your written account, and if they read your sworn petition and agree that there is an immediate and present danger, they grant a temporary injunction right there on the spot.
Just based on the paperwork?
Just the paperwork. Legally, this is called an ex parte order.
Ex parte, meaning the judge is making a decision based solely on what you wrote, without the person you're accusing, the respondent, even being in the building or knowing about it yet.
Right, because the immediate safety of the petitioner outweighs the standard procedure of having both sides present. Once the judge signs it, the clerk electronically transmits that order to law enforcement within 24 hours. The sheriff's office then physically serves the respondent with the paperwork. And that service can happen at any time, 24 hours a day, 7 days a week.
Which creates an instant legal shield around the victim. But since the other person didn't get to defend themselves, that shield obviously can't last forever.
No, it doesn't. It creates a protective window that lasts for up to 15 days that gives you immediate safety. But within those 15 days, the court has to schedule a final hearing. That's the moment where the temporary order is evaluated to see if it should become a permanent injunction. And that's when both sides have the constitutional right to be in the courtroom and present their case.
Okay, wait, hold on. We constantly see on TV that to prove abuse, you need, like, a mountain of physical evidence. We're conditioned to think you need ring camera footage, a stack of hospital records, or a dozen police reports just to get a judge to believe you. Are you saying that's not true here? When that final hearing happens, how does a judge actually decide who to believe?
The idea that you need a mountain of physical evidence is honestly one of the most pervasive and dangerous myths about the domestic violence legal system. The official guidance from the Florida courts actually goes out of its way to dispel this. They emphasize a really profound reality. Your testimony alone is enough.
Just taking the stand under oath and telling the judge what happened?
Yes. Courts recognize the reality of domestic violence. They understand that abusers operate in secret. Survivors are often isolated, their communications are monitored, and they face insurmountable challenges in gathering physical evidence, like photos or threatening texts, when someone is actively controlling their life. So if your spoken testimony in court is credible and detailed, the law considers that legally sufficient to grant a final injunction.
Wow. The bar for proof must be completely different than a criminal trial, then. I mean, in a criminal case, the prosecutor has to prove guilt beyond a reasonable doubt. If a judge is making a ruling based entirely on testimony, they can't possibly be using that same standard.
They aren't, because this is a civil proceeding, not a criminal one.
Oh, I see.
Yeah. Florida Statute Section 741.3 AG6B establishes a unique, much lower standard. The law simply says the judge may grant the injunction when it appears to the court that the petitioner is a victim of domestic violence or in imminent danger.
It appears to the court. That's incredibly broad. It gives the trial judge a massive amount of power to just kind of read the room and make a judgment call.
It does. The system is designed to put deep trust in the trial judge. If we look at how higher courts view this, specifically a standard established in a major case called Moore v. Hall appeals courts almost always defer to the trial judge. The higher court acknowledges that the trial judge was the one actually sitting in the room, looking at the survivor, observing their body language, hearing the raw emotion of their testimony firsthand. Unless the trial judge made a completely irrational choice that no reasonable person would make, the appellate court just won't second-guess them.
But the trial judge can't just operate on a vague gut feeling, right? There has to be some sort of framework they use to decide if the danger is real, especially if there isn't a history of extreme physical violence yet.
Right, there is. The statute provides a very specific roadmap for the judge. Section 741.306 lists 11 distinct factors the judge must evaluate. They look at obvious things like a history of threats, stalking, or previous physical violence. But they also look at highly specific markers of coercive control. For example, the judge must consider whether the respondent has intentionally injured or killed a family pet.
Putting family pets directly into the domestic violence statute is so revealing. I mean, it shows the court understands that harming a dog or a cat isn't just about the animal, it's psychological warfare. It's a way to demonstrate power and keep the victim terrified to leave.
Exactly. The law looks closely at how the abuser isolates the victim. The judge considers if the respondent has physically restrained the petitioner from leaving the home or from calling 911. They evaluate the destruction of personal property, and the statute specifically calls out the destruction of telephones or communication equipment.
Because if you smash someone's phone, you cut their lifeline to the outside world.
Right. You control who they can talk to and when they can ask for help. And the 11th and final factor in that statute is the most encompassing. The judge must consider if there is a pattern of abusive, threatening, intimidating, or controlling behavior over a period of time that shows a continuity of purpose. The court is looking at the entire ecosystem of control, not just a single physical strike.
So let's assume the judge hears the testimony, looks at those 11 factors, and agrees that the danger is real. What tangible power does this final piece of paper actually hold? I picture a final injunction, like a custom-built fortress. The judge doesn't just throw up a generic brick wall. They can install specific locks, define the perimeter, and create safeguards tailored to what the survivor needs to safely rebuild their life.
That's a great analogy. And one of the most powerful elements of that fortress is the literal house. Under Section 741.30, the judge can award the petitioner temporary exclusive use and possession of the dwelling they share.
The judge can legally kick the abuser out of their own house, even if their name is on the lease or the mortgage.
Yes. The respondent is ordered to leave, and the petitioner gets to stay safely in the home. Beyond the physical boundaries, which include a strict no-contact order keeping them away from your home, work, and vehicle, the judge can drastically restructure family and financial dynamics. They can establish a temporary parenting plan right there in the courtroom. This plan can award the petitioner up to 100% of the time sharing with minor children.
That is massive. The abuser can lose all access to their children instantly.
The court's priority is the safety of the children and the victim. The judge can also order temporary child support or direct financial support for the petitioner. They can mandate that the respondent complete a certified batterer's intervention program. We mentioned pests earlier. The judge can award exclusive care, possession, or control of an animal to the petitioner and legally forbid the respondent from having any contact with that pet.
Wow. Okay, so we have housing, full custody, financial support, protection for pets, and a perimeter around the victim's workplace. What about the ultimate escalation of danger? Does the injunction address weapons?
This is one of the most critical safeguards in the entire process. Under Florida Statute, Section 790.233, the moment a final injunction for domestic violence is issued, the respondent is legally stripped of their Second Amendment rights.
Wait, immediately?
Immediately. It becomes illegal for them to have in their care, custody, possession, or control any firearm or ammunition. The judge's order serves as formal notification that possessing a weapon is a first-degree misdemeanor, and they are required to surrender all firearms.
That's incredible. So how long does this custom-built fortress stand? Does it automatically expire after a year, forcing the victim to come back and prove they are still in danger?
Actually, unless the judge specifically writes an expiration date into the order, a final injunction remains in effect indefinitely.
Indefinitely.
Yeah. It stands as a permanent barrier until either the petitioner or the respondent goes back to court, files a motion to modify or dissolve it, and actually convinces a judge to lift the restrictions.
But a fortress is useless if nobody is guarding the perimeter, you know? A piece of paper with a judge's signature can't physically stop someone from walking up to your front door or following you to the grocery store. If the respondent just decides to ignore the judge and test the boundaries, how does the system actually defend that wall?
The consequences for breaching that perimeter are severe, and they escalate quickly. Enforcement is governed by Section 741.31. If the respondent violates the injunction in any way, texting you, driving past your house, or refusing to surrender their firearms, it becomes a criminal offense. A first-time violation is a first-degree misdemeanor.
And if they don't learn their lesson and violate it a second or third time?
The law aggressively targets repeat offenders. If someone has 2 or more prior convictions for violating an injunction and they violate it again, the crime is upgraded to a third-degree felony. On top of the criminal charges, a violation automatically triggers a mandatory requirement to attend a batterer's intervention program. The court also has the authority to award the petitioner civil damages to cover any injuries or financial costs caused by the violation.
Okay, those are the long-term consequences. But in the immediate moment of a violation, say the abuser is standing on your front lawn right now, screaming at your door, what happens when the police arrive?
This is where the true teeth of the enforcement mechanism lie. Florida Statute Section 901.156 grants law enforcement officers an extraordinary level of power in these specific situations. If an officer arrives and has probable cause to believe the respondent has violated the injunction, the officer is authorized to arrest them right there, completely without a warrant.
Warrantless arrest changes the dynamic entirely. It means the police don't have to go wake up a judge, present an affidavit, and wait for permission while the abuser is standing in the front yard.
Exactly. The state takes the burden of enforcement entirely upon itself. And get this, the officer can make that arrest even if the petitioner is terrified and begging the police not to take the abuser away.
Wait, even if the victim protests?
Yes. Abusers often try to manipulate or threaten victims in front of law enforcement to avoid arrest. The warrantless arrest provision neutralizes that tactic. The victim doesn't have to press charges. The state enforces the court's order independently.
Wow. Okay, but what if the violation isn't an immediate physical threat? Let's say the respondent sent a threatening email yesterday. The police might not make a warrantless arrest because the person isn't physically there causing a disturbance. Does the victim just have to accept that the perimeter was breached?
No, the system has a built-in alternative route for that exact scenario. The law requires every judicial circuit to have a designated central intake point for reporting violations. In Broward County, that's the clerk's office.
Okay.
So if the police don't make an arrest, you go straight to the clerk. They are legally mandated to sit down with you and help prepare an affidavit documenting the email, the text, or whatever the violation was. That affidavit is sent directly to the judge and the state attorney. The state attorney then has 30 days to decide whether to file criminal charges or hit the respondent with a motion for contempt of court.
We've spent this entire time dissecting the domestic violence injunction, but relationships and human behavior are incredibly varied. What if the person terrorizing you doesn't fit that strict family or household member definition we talked about earlier? Say it's an ex you casually dated for a few months but never lived with. Or what if it's a neighbor who's become obsessively hostile?
Well, Florida law recognizes that danger comes from multiple directions, which is why there are actually 5 distinct types of injunctions for protection. We've mapped out domestic violence under Section 741.30, but the other 4 are governed primarily by Section 784.046 and 784.0485. Finding the right legal tool is essential because you have to meet the specific criteria for the type of relationship you have.
Let's look at the ex you never lived with. They don't qualify for the domestic violence track because there's no shared household and no shared child.
Right. For that scenario, you would file for a dating violence injunction. The legal requirement here hinges on the timeline and the nature of the relationship. It must have been a romantic or intimate dating relationship, and importantly, it must have existed within the past 6 months.
Okay. And what about the hostile neighbor? Someone where there's absolutely no romantic history and no family tie.
That falls under a repeat violence injunction. The standard for this one requires a documented pattern. You must be able to prove there have been at least 2 separate incidents of physical violence or stalking directed at you or your immediate family. And again, timing matters. At least one of those incidents must have occurred within the last 6 months.
What are the final 2 types of injunction?
The 4th type is a sexual violence injunction. This is available if you're a victim of sexual violence and you're actively cooperating with law enforcement in their investigation. It also has a really powerful proactive feature. If the respondent was incarcerated for the crime against you and their sentence is up, the court can issue an automatic 15-day temporary injunction the exact moment they are released from prison.
Oh, wow. So there's no gap in protection there.
Exactly. And the 5th and final type is a stalking injunction, designed specifically for victims of repeated malicious harassment or cyberstalking.
So if a judge grants one of these other 4 injunctions, dating, repeat, sexual, or stalking, is the actual protection you receive identical to the domestic violence injunction? Do you still get the full custom-built fortress?
The physical perimeter is the same. A no-contact order keeps them away from you, your home, and your job, regardless of which injunction you file. The critical difference is the scope of the relief regarding your personal life. Only the domestic violence injunction allows a judge to order a parenting plan, mandate child support, award spousal support, and grant exclusive custody of family pets. Yeah, the other 4 injunctions are strictly designed to keep the dangerous person physically away from you. They do not give the judge jurisdiction to restructure your family life or your finances.
Which logically tracks, honestly. I mean, if there was no shared household or shared family to begin with, the court doesn't need a mechanism to untangle those lives. It just needs to build the wall.
Right, exactly.
When you zoom out and look at everything we've covered, from walking into the clerk's office and getting an immediate 15-day protective shield, to proving your case on testimony alone, to the judge stripping away firearms and utilizing warrantless arrests, it's pretty clear this system operates on a totally different wavelength than the rest of the legal world.
It really does. And when you look closely at how this law is written, especially the specific behaviors the judge is forced to evaluate, you see a profound philosophical shift in how the state views abuse.
Tell me more about that shift, because on the surface, it just looks like a list of bad things a person might do.
Historically, the legal system has been entirely reactive. It waits for a crime to happen, a physical assault, a broken bone, and then it steps in to punish the offender. But by explicitly writing things like destroying a cell phone, harming a pet, or utilizing a sustained pattern of intimidation into the statute, Florida law explicitly recognizes that abuse is rarely just a physical strike.
It's a psychological cage.
Precisely. By making these specific coercive behaviors grounds for an injunction, the law is actively shifting from merely punishing past crimes to preemptively dismantling an abuser's toolkit of control. The court is looking at the hidden mechanics of fear and disabling them before they escalate into a tragedy.
Dismantling the abuser's toolkit of control. I mean, it's not just handing the victim a shield to hide behind. It's actively disarming the threat and taking away the levers of power the abuser uses to keep the victim trapped. Before we wrap up, we want to make sure you have the exact resources mentioned in our sources today. If you are in immediate danger, do not wait. Call 911. For after-hours filing help specifically in Broward County, meaning nights, weekends, or holidays when the courthouse is closed, you can call Women in Distress at 954-761-1133. And for help anywhere in the state, the Florida Domestic Violence Hotline is 1-800-500-1111.
It is so vital to know that these options exist. The law has carved out this path, waived the fees, and mandated that the clerk's office help you navigate it. You do not have to do this alone.
We started today talking about how the legal system usually feels like a slow-moving glacier. But remember, when the smoke appears and the danger is real, the law has built a mechanism that shatters that ice. The fire alarm is sitting right there on the wall. You just have to know your rights well enough to reach out and pull it.
This episode was produced by Bach Pro Se. Run your own legal research at prosay.tribach.com.